Voice of Parliament, from TBC.
Yes, please.
I'm scheduled to speak at 8 in the afternoon. But the matters that I have got to say would be that many of the things that have been put into the penal code and the evidence ordinance, none of those corrections can be now made because already all the corrections have been made.
Your Honor can take that up in the evening.
Because everybody will be talking about it, and for me to say it at the end of it, if that be so, let me have the chance of speaking first.
No, there's no time. No time. You can have it. You can have it.
I mentioned it to the Honourable Minister,
Right.
because all the discussions would be of no use if at the end of it we are not going to proceed with these things.
Yeah. So we can organize it in the afternoon. Then no problem. Okay. Thank you.
Honorable M.A. Sumandran, you have 10 minutes.
Thank you, Honorable Deputy Chair of Committees, for this opportunity to speak today. I wish to right away commend the Honorable Minister of Justice for a statesman-like speech that he delivered moments ago when he introduced these bills about an inclusive country, a country in which all citizens from whatever background they come feel and know that they are equals in this country. And to that end, all efforts that he takes as a responsible minister, as a Minister of Justice of the country, I would like to extend our fullest cooperation and our wishes that he succeeds in that endeavor. I'd like to quote now from what the visiting Indian Minister of External Affairs, who is in the country today, Dr. Subramaniam Jaishankar, said a little while ago. I quote, "Our support for the reconciliation process in Sri Lanka is long-standing, as indeed for an inclusive political outlook that encourages ethnic harmony. It is in Sri Lanka's own interest that the expectations of the Tamil people for equality, justice, peace and dignity within a united Sri Lanka are fulfilled. That applies equally to the commitments made by the Sri Lankan government on meaningful devolution, including the 13th Amendment to the Constitution. The progress and prosperity of Sri Lanka will surely be advanced as a consequence, and I wish to thank the visiting Minister of External Affairs of India on behalf of the Tamil National Alliance for those comments, and I will also wish to thank the President, who had reportedly given the assurance to the visiting Minister. I quote again from the Minister that the President firmly stated his commitment to the well-being, progress and opportunity to all our citizens, Sinhala, Tamil, Muslim and all. And if that be indeed the vision of the government, our support for all your processes to achieve that end will continue to remain. We have before us some bills. You have sought to amend the evidence ordinance and the penal code to change archaic language and to bring it in line with what is presently the affairs that are presently prevailing. These were laws that were enacted during British regime, and naturally the king or the queen or the governor etc. all still remains in our statute books, and you have thought it fit to change it. But the Honourable Minister, you must be well aware that these are not the only piece of legislation that has all this archaic language. There are plenty more. But I also wish to put on record another fact that perhaps a lot of people are not conscious of, and that is a lot of the body of law of our country still remains English common law. We don't have statute law. For instance, the entire administrative law of our country, where our courts exercise writ jurisdiction, there are no statutes, there's nothing written. Everything is English common law even to this day. Laws on a lot of commercial matters like insurance, bills of lading, etc. are all English common law. The law for the time being in England is a law here, and that is the civil law ordinance. That's what the civil law ordinance says. And that's not a bad thing. But we must be conscious that that is the case. Another one is the contempt of court. We don't have substantive law as statute on contempt of law. It is a law for the time being in England that applies to contempt. And scandalizing the court is no more an offence of contempt of court in England. That has been abolished. So to keep in line with the developments in England as regards the law, to keep in line with the development of the law as it prevails today in South Africa, because our common law is Roman Dutch law and the judgments of the South African courts are also relevant to that extent. And with regard to penal code, code of criminal procedure, civil procedure code, evidence ordinance, we keep in touch with the developments in India, because those laws in India are almost identical to the statutes that we have. So this fact that we are connected to the region, we are connected to our colonial masters, even though we say we have become a republic and discontinued that legal that connection, colonial tradition, is not true. The body of law, most of it in our country still is English law and Roman Dutch law. And I think that needs to be emphasized, and attempts like these, although they are salutary, doesn't actually remove us from the fact that we are a common law country with British legal tradition and Roman Dutch law as our common law. I also want to, before my time runs out, refer to this other bill, that is Bail Amendment Act. We welcome the fact that you are increasing the fines in those schedules. But with regard to bail, I wish to support the honourable member who preceded me, who referred to certain statutes that deny bail, that says that if there is a prosecution under that act, there is no bail, particularly Antiquities Ordinance. He mentioned that, and I know as a matter of fact, in several areas, even accidentally some stone is damaged, persons are brought before court and they have absolutely no chance of defending themselves. If they want to defend themselves, they have to be in remand.
Honourable Member, you have 2 more minutes.
Thank you. And therefore, I together with my honourable friend, I wish to urge you to look at some of these statutes where bail is denied and to make it the norm to grant bail and the judicial discretion to be retained. Since time is running out, I want to refer to the Tamil political prisoners issue. I want to cite one example, just one example of those who are of a person called Edward Sam Sivalingam, who was arrested on 4th August 2006. He was my client. I appeared for him in a fundamental rights case in the Supreme Court, which was dismissed because he possessed a travel identity card issued by the LTTE. Those days, if you were in the LTTE controlled areas and you had to travel out, you have to have that card, otherwise they won't let you travel out. And because of that, he was identified as an LTTE, which is wrong. Now, there is this book, Judicial Mind in Sri Lanka. For lack of time, I will place cover page of that book and page 242, Jantari Ameda Gunratna, Kishali Pinto Javadhan and Gehan Gunatilaka wrote this in 2014. They referred to this case It appears at page 242, I'm tabling that. Now this person, after 10 years he was indicted. After 10 years of detention under PTA, he was indicted in 2016, but the case is still going on. Nothing has happened in the case because of two police officers who are involved in recording the so-called confession are dead. I remember the time when if the police officer was dead, they were released. I mean, that was the only evidence. Persons were released.
Honorable member, please wind up.
Thank you. But in this case, this is one case that I know. I'm sure there are several other cases like that. A father of 3 children. He was a church worker who is supposed to have introduced one person to another person, supposed to be a driver who transported some explosives. And there is no evidence against him. The confession cannot be proved, but he is still languishing in prison. This is the fate of the majority of those whom we call the Tamil political prisoners. You have been releasing many people. I wish to commend, give me one moment, I'll conclude now. I wish to commend the Honorable Rathwatha seated next to you. He told me that about 10,000 persons have been released from prison. I applaud you for that. But look at the plight of these people who have been there 16 years, 15 years, 20 years, 25 years without a trial and no evidence. I urge the Honourable Minister to please look into this. Your time in the government might be short-lived. So while you are there, please look at this and grant us also relief. Thank you very much.
Thank you. Honorable C.V. Vigneswaran, you have 3 minutes.
Thank you, sir. After my suggestion yesterday at the Ministers' Consultative Committee meeting, I had occasion to refer to the 1972 Constitution, the Administration of Justice Law, and the current 1978 Constitution, since as a law lecturer I had thought that the matters referred to in these amendment bills may have been already dealt with. I was able to find a lot of important matters to be considered by the honourable members of this August Assembly before we pass these bills. With regard to these bills, Honourable Speaker, the crux of changes contemplated are to change the reference to British institutions, including references to proctors and advocates, which were inserted into our statutes during British times in the Penal Code and Evidence Ordinance, and the enhancement of fines as per the Bails Act. Let me deal with the Penal Code and Evidence Ordinance first. I find the corrections contemplated by this government with regard to lawyers have been already dealt with in the 1972 Constitution, Administration of Justice Law, and current 1978 Constitution. Now, Section 36 of the Administrative Justice Law states, every reference to any other existing written law to an advocate or proctor shall be read as and construed as reference to an attorney at law. So you would see it has already been taken into consideration. Then, presently, Article 168(1) of the current 1978 Constitution says, unless Parliament otherwise provides, all laws, written laws and unwritten laws in force immediately before the commencement of the Constitution shall mutatis mutandis and except as otherwise expressly provided in the Constitution continue in force. Then the next article, 169(1) states, unless the Parliament otherwise provides, any provisions of the Administration of Justice Law 44 of 73 which are inconsistent with the provisions of the Constitution shall, to the extent of such inconsistency, be deemed to be repealed. That means there are sections of the Administration of Justice Law still in force, and that is what I meant earlier. Thus it would be seen that the provisions of the AJL do still stand and are valid. Under the circumstances, the amendments in respect of attorneys at law seem redundant. Not only redundant, they could create confusion. As regards the reference to British institutions, including the Queen, this has been dealt with through Articles 12 to 15 of the 1972 Constitution. Article 12(1) reads as follows: unless the National State Assembly otherwise provides,
Honourable Member, you have 1 more minute.
And it goes on, the laws so continuing in force are to be referred to in the Constitution as existing law. Therefore, it appears the matters relating to British institutions have already been taken care of. Thus, these amendment bills may not be necessary. As for the Bails Act amendment, it would be prudent to add a section which specifies that the increased fines would be applicable to offences committed after the enactment. In this connection, it is necessary to read Article 13(6) of the Constitution, which reads as follows, and I am not going to read that out. Hence, subject to the addition necessary to protect the rights of prisoners under the Bails Act, the other two amendments may be dispensed with or reviewed upon, because it will be wrong to continue with it in a specific manner when there is already a general law pertaining to it. When there is a general law and a specific law on these matters, it may be argued, since there are specific laws in regard to certain acts and not in regard to others, that the other one may not come into force. So this is for the consideration of the Honourable Minister. Thank you.
The Voice of Parliament, from TBC.